Okay, good morning. This is Senate Judiciary, February 28th, 2024, continuing our discussion of S-259 and activating climate change cost recovery. And we have with us, delighted to have with us, the Attorney General of the State of Vermont, Sherry Clark. Thank you, Madam Attorney General.
Thanks for having me. I'm sorry that I'm not an HVAC engineer.
Well, I am too, but this proves climate change is real. We can't get the State House to a normal level of heat.
Yeah, it's warm. Well, it's really nice to be here, and thanks for having me. I know that the Attorney General's office has come up in your conversations about S-259, so I wanted to just come myself. We also submitted written testimony with some attachments for your pleasure reading if you so desire. What I would like to do today is just share my position on the bill and also just give you an update on the lawsuit that we filed a couple of years ago against fossil fuel companies under a consumer protection theory. So first, about the bill, I support the policy behind this bill. I believe in a polluter pay model, and it makes sense that the major contributors to the climate crisis we're experiencing here in Vermont should pay a fair share when it comes to our costs with dealing with that crisis. I also want to note you've been really thorough in your consideration of the bill and the folks that you've listened to. I really appreciate that and want to kind of note it. I've noticed. And I don't want to go into details about our legal theories and for obvious reasons that I think you've discussed. But I do want to say that there are sound, good faith arguments to be made. And while I think there's a risk, of course, and there's no guarantee, of course, if we are sued, I will proudly defend this bill. There's no playbook for this kind of bill, and it's hard to predict. But I did want to come in and just say a few words and tell you my perspective. I also know lots of people are interested in our case against Exxon and others, so I wanted to give you an update on that and just take a moment. A couple of years ago, we sued major fossil fuel companies on a consumer protection theory, and the basis of that lawsuit is two main things. One, since the 1960s, the fossil fuel companies knew that their products were impacting the environment and the climate, and they were obfuscating that and being untruthful about that. And two, which deprived consumers of making choices, in addition to many other problems. And two, more recently, using a greenwashing theory, they greenwashed. They said their products were greener than they really are. And so we sued them. Shortly after that, we sued them in state court. They moved the case to federal court. So the past 2 years have been spent fighting over which court we should be in, not collecting discovery and working on the actual case. We had fully briefed that issue of which should we be in federal court or state court a year ago. And very recently, like earlier this month, the court finally decided and remanded the case back to state court, decided we should be in state court. So now we will begin the motions practice that always begins our cases, it seems. It doesn't necessarily have to, but it seems to. They have until, I think, April to file their motion to dismiss, which of course we will oppose. And by the end of summer, all of that issue will be fully briefed, and it'll be in the court's hand to decide whether the motion would be granted, whether the case would be dismissed or not. So that is the basics on our Exxon case. And I did want to mention, because this is somewhat relevant to the conversations you're having about this bill, what we're asking for in that case. We're asking for civil penalties, which under the Consumer Protection Act are significant. It's up to $10,000 per violation. That is in case law widely believed to be per consumer per violation. So it's very, very large in this case. disgorgement of profits resulting from the deceptive acts that the fossil fuel companies perpetrated, injunctive relief to prohibit further deception, and also to rectify past deceptive conduct. So that could look like required disclosure about the role that the products play in the climate crisis. And of course, our litigation costs and fees, which I assume will be not insignificant by the end of the case. So there you have it. I'm happy to answer any questions you might have. And we also filed with a written testimony a copy of, I think, the complaint of that lawsuit, and probably the court's, I hope I'm getting this right, probably the court's order remanding the case back to state court.
Yep.
Getting a nod. Okay.
Well, no, it's very helpful to have your, and I understand not getting into the strategy. Actually, we invited the industry to give an opinion on the bill, and they declined rather waiting for litigation. So I do want to, I know Lead Counsel Michael Grady is on Zoom, and I want to make sure we have a fence around the money. I know that settlements usually go to the general fund. So if you receive the settlement, if we receive the settlement under 259, I would like to make sure there's a fence around that money to go to climate resiliency or whatever else is related to the damage done. If it's not part of the bill, and I can't remember whether it is or not, just to mention that.
Okay. Yeah, that makes sense. I mean, in terms of this isn't a bill, obviously not a settlement, but when it comes to settlement, it's true that largely the settlement funds do go into the general fund, but I can think of several examples where they don't. In some cases, like the tobacco fund, obviously was created as a result of the consumer tobacco settlement. The opioid process, where the settlement has like an opioid council, I can't remember what they're called, that make decisions. We also have, this probably wouldn't be applicable in this case, but we also have a case, we have cases, but one I can think of more recently, when we settled with Dollar General, knowing that we couldn't track down every consumer who paid, $6 for milk instead of $3 for milk. We had a donation of $100,000 going to the Vermont Food Bank. So there's other mechanisms than the general fund. Yeah.
Other questions for Attorney General Clark?
You asked mine, which was about, utilizing that settlement in this special fund that's identified to really make sure it was to climate. So you're reading my mind again, Senator Sears.
Oh, scary. After a year and a half on the same page.
Some things.
Any other questions? Thanks so much for coming over.
Yeah, thank you.
Mike, are you on Zoom? We plan to take this up probably the Tuesday or Wednesday when we get back.
Okay.
Will that give you enough time for a redraft?
Yep, I already emailed Secretary Moore to see if she had language or if she had somebody I should work with. And she doesn't have language, but she said I should talk to Megan O'Toole, an attorney in the Climate Action Office. And so I will work with Megan and whomever else she would like me to work with over the next week or so to get you a redraft.
And, well, hopefully you get better and go clear. So we can stay tuned. We'll try to book you in the day that you're more or less free to do markup on the bill. I don't think we have more testimony coming.
I did want to hear from Carla from the Environmental Justice Office that the A&R recommended.
Okay.
I'm also happy to have Carla and Mike connect, because I just want to make sure we've got environmental justice centered in the bill. And if it makes more sense to have Carla work with Mike to make sure that that's in the bill, that's fine too.
It's up to you. I don't care. But as long as it, I think it would be better to hear from Carla.
Well, Carla works for A&R, correct? And
Yes,
she works for the secretary's office, which is where the climate action office is as well. So when I connect with Megan, I can basically ask that Megan consult with Carla and include any of Carla's input into any proposed language.
And then at that meeting, we can hear from Carla. Is there anybody else that committee members would like to hear from? So I don't wanna, does this bill have any appropriation in it, Mike?
Not specifically, no. But it does have the cost recovery demand and how that money would be used for the infrastructure project. So I would not be surprised if Secretary Bloomer sends it to appropriation. Maybe even to finance as well, because the cost recovery demand, that's revenue. So I could see it going to both of the money committees by rule.
Mm-hmm. Anything else on this bill? Anybody in the audience who wishes to give us advice? We have a few minutes. No advice?
Mr. Chair, I sent on
Yeah.
behalf of the group the written.
Yes,
just
I
sent
got
everything
that.
for the record, so.
And you're, could you identify yourself?
Yes, Anthony Arpino with the Conservation Law Foundation, was
Right.
working with Jeff Hand, who was working with Vermont Public Interest Research Group. We've also got Lauren Earl here from BCD, who's been consulting with us.
Yeah. Have you got a copy of their memo, Mike?
Yes, I do.
Okay. Is there anything, committee, if you want to go over it briefly while we get a few minutes to look at it, if there's anything stands out that you do like or don't like in the memo?
The AG's memo, or which memo?
It's this one right here.
Oh, yeah.
that's the AG's now.
It recommends that we end the covered period in 2023 rather than 2020.
That's fine with
I would
me.
agree with that.
And allowing the treasurer to may consult. Housing is one of the climate change affected areas.
And do you want buyouts like Secretary Moore
Yeah,
recommended?
yep. Yeah, there are areas that continually flood and the people have no way of getting out of those areas. And so if there are buyouts, it might be potential to get out of it. I know every town's probably got some areas where, yes, sir.
I just wanted to, it sounds like your intent, also one of our suggestions was to just make clear that it's not just the cost to the state itself, but also
Yeah.
to residents. It sounded like
Yeah.
that. We were trying to react to what we heard from the
Yeah.
committee.
No,
and wanted to sure.
I think our intent is state infrastructure, people's homes, people's businesses, other things that have been adversely impacted by the climate change, and then who's responsible, strict liability. So the buyout would be, if your business is constantly flooding, your downtown Montpelier, and, you can't reopen your business, who's responsible for that? You?
Yeah.
Or do you have to bear the brunt of that, or should the companies that contributed to the climate change bear the brunt of that cost?
Couldn't agree more. My law practice involves representing a lot of the businesses downtown here in Montpelier. My office is on the second floor. The first floor is entirely flooded. They're still in the slow process of fitting it back up. So I feel as personally, I guess my point was just, one of our recommendations is for the language to make clear that you also intend, when the treasurer tallies up those costs, that those types of businesses and the farmer you heard from, that those costs be accounted for as much as possible. And just so you know, Mr. Chair, we've shared that proposed language with the treasurer, so I know you're going to hear from the treasurer's office as well. So to the extent that the treasurer agrees with it, they can convey that to Mike.
No, I think generally that was my goal. I realized as the bill got introduced, it was modeled after some other states. But I want to make sure that individual Vermonters are covered who have had damages. You know, I living in a zone of contamination as I do, from PFOA damage taught me an awful lot. Fortunately, we've been on town water, or village water, since I've been there in the 1970s. So I never had to have a well. But the loss of personal, you know, I shouldn't be growing things underground like potatoes, for example, because the ground is contaminated. And so, you know, I got a $4,000 settlement from St. Gobain, which was nice, and went right into paying off some debt. But, you know, it doesn't cover the cost of damages to my home value, which for the next 100 years, that home's going to be in an area of contamination at least. Senators.
Thank you. So speaking of other states that have done similar things, this might be a question either for Anthony or Mike. I just wanted to go back to the question or the point that was raised on page 5 from ANR, the other areas of clarification, you know, regarding, you know, extraction worldwide versus what was consumed in Vermont. And I just want to make sure that we're not even coming close to running afoul of the Dormant Commerce Clause.
Yes,
and so do either of you have thoughts on that point that was raised by ANR?
I defer to Mike because I know when he started your walkthrough, he did testify on dormant commerce clause issues, but I certainly speak to it if Mike doesn't want to.
So, this is Mike O'Grady. The concern that you're pointing to is on page 5, lines 1 and 2, the fact that fossil fuel business is engaging in the extraction of fossil fuels. Is that your concern?
Yes, part of it, but also I think that could be considered part of it. But, you know, I also know that the exact formula for how this gets determined hasn't been chosen, is my understanding, because that will end up being ANR's job to choose the formula. And I just want to make sure that we're not reaching beyond our borders in such a way that would be problematic. And so, I mean, if you already covered that in,
well, I think if you go to page 7, lines 15, and it's how the cost recovery demand is proposed and the bill is introduced to be assessed, and this may change, but it's equal to an amount that bears the same ratio to the cost to Vermont, not to the cost globally, the cost to Vermont from the emission of covered greenhouse gases during the covered period as the responsible party's share of covered greenhouse gases bears to the aggregate applicable shares of covered greenhouse gas emissions for withholding. So it is limited. What is going to be recovered is that party's share of the cost to Vermont of their emissions. Now, you could clarify that language and somehow say it's emissions to Vermont, but this language itself is limiting what is recovered to cost in Vermont. I don't think you're going to totally eliminate every commerce clause challenge. I think even when a law is non-discriminatory on its face, a challenging party can allege that it still is discriminatory in effect, or so discriminatory on commerce that it exceeds the state's legitimate interest. I would not be surprised if similar claims were made, regardless of the text of the bill.
Thank you.
So,
I'll just go ahead and sit in the chair. Again, Anthony Arpino of Conservation Law Foundation. I do want to recall though, and see if Mike agrees, he did, when he walked through the bill and spoke to this issue, he referenced the Supreme Court's recent pork producers case, which basically involved regulation of conduct that occurred outside the state of California when the effects of the activities by industry were felt inside the state of California. And that was an important case, and I think one that gives us hope that this approach is consistent with the Commerce Clause jurisprudence of the Supreme Court.
So Anthony referenced national pork. And national pork, the holding is effectively that there isn't what's called a per se rule against extraterritorialism. And extraterritorialism means that a state's law somehow regulates or controls conduct outside of its jurisdictional boundaries. And in national pork, it was pork producers in Iowa effectively that were challenging California's law. And the court said there isn't a per se rule against extraterritorialism because Iowa farmers needed to raise their pigs a certain way in order to sell into California. Wasn't per se a violation of the Commerce Clause. What the court needed to do was to apply the traditional Commerce Clause analysis. And they almost didn't do that. They almost blew that up, but they decided not to blow that up in the end. And they said that no, that they didn't think it was discriminatory using the traditional Commerce Clause analysis. That kind of thing will be part of any litigation, in my opinion. You no longer have that specter of per se extraterritorialism lending or causing a court to hold that it's unconstitutional under the Commerce Clause, but you're still going to have Commerce Clause challenges. It's still going to be.
well, I agree.
Thank you.
We need to do the best job we can, but I'm encouraged that the Attorney General is ready to defend this law should it pass.
And the other thing I wanted to say on this point in reaction to what you said before, Senators, here is the acid rain analogy is completely apt. If we just looked at emissions from products in the state of Vermont, we're missing what's causing the problem, and the effects, as Senator Vyhovsky said, they don't respect our state boundaries, and the costs are being felt here. So in terms of making this, if there's going to be litigation, we want it to be worth the effort. And if you look at worldwide emissions, that makes the recovery number potentially much more significantly
I
higher.
was thinking of the farmer where I get my maple syrup from. It's a state line farm. It's right on the state line with New York. And he's obviously been impacted by climate change, but part of his farm is probably in New York and parts in Vermont. But and Senator Vyhovsky, final question or comment?
I mean, my question largely was answered, and I respect that we want to have what we're doing be defensible. And if, as Mr. Arpino pointed out, if we focus only on the emissions in Vermont, we're missing so much of what is impacting Vermont. And the way I read it, focusing on the cost to Vermont allows us to narrow that in without missing out on.
Absolutely. Absolutely. It's been an extremely helpful meeting, and Mike, thank you very much for your guidance here.
Thank you for the opportunity.
Participate from my office, so I wasn't sneezing all over you.
So, I think what we have is actually an administration, treasurer, attorney general, and Senate committee that support this effort, and we will pick up with it and try to get a bill out next week. a week after town meeting, excuse me. I will not be here next week. Those of you who are, well,
Enjoy the bizarrely warm weather, I guess.
you and I, well,
Yes.
we're gonna enjoy warm weather. I was looking for pictures of Thursday. Anyway, we're gonna switch to S58. So S58 is the omnibus crime bill. Public safety. And as we know, we have a witness from the, but if she's not ready, we can start with John.
So attorneys will be here momentarily.
Eric is here. My God, we get the whole crowd.
Yes, the 18th.
Holy cow, it's hot in here.
Yep.
Tell me
It was
about it.
warmer yesterday. It was cooler today than it was yesterday.
Feel free to.
What's that for today? SVP and SCH.
Okay, thank you.
Just because they were.
That is hot in here.
Excellent.
I'm all ready.
Right, right. You didn't have a mood court?
Yeah. I
Eric,
don't even have a dog anymore to do.
Eric asked if he could go first.
yeah, Eric can go first. His areas are expertise are raise the age.
That's raise the age and.
The big,
Okay.
big 16, big 15. The big 15,
Number TBD to be determined.
well, 3 plus 12 is 15, minus 1 is 14.
Okay.
That's right,
So it's the big 14.
right.
Some people aren't happy that we took out,
I know. Some people aren't happy with what we're adding in.
well, that's true. So this is a bill to keep everybody unhappy as much as possible. No, it's, I want to say, given an email I got to start off with on Raise the Age, I think we're doing the right thing. The question is, why is it part of a public safety bill? And the reason that it is because it actually improves public safety by raising the age. You will have 19-year-olds who you will never hear from again because they're gonna go through diversion, they're gonna go through juvenile services where they get the treatment they need. You know, about 99% of them are not a problem. It's that 1% that are, and usually they've committed one of the big 12 crimes or the newer crimes, and they can still be taken up into adult court. So I think it overall is actually public safety related in that there's much more success in the juvenile system than the adult system for those young people. That's just my opinion. I realize I've gotten emails saying, you know, I'm wrong, it should be the other way around, it should go lower. So everything from the science as well as the report from the Justice Lab indicates that we're in a safer mode by diverting kids as much as possible.
So I completely agree with that. And I think raise the age, as you say, does improve public safety. Which is why I'm still concerned about the part of the amendment, the new part, the monthly progress reports, because what we've done before is to just put the date out a year. So it was still in law that we were going to do this, put out a year. Now we're adding in a series of conditions, and it's, I know it's not exactly what we're saying, but it seems to imply that we're saying all of these conditions have to be met before we can raise the age. And I feel like it gives the administration a very easy way to come in January of next year and say, we've only completed 3 of this list. It's going to be another 2 years. So we want you to raise the age out, and they will point to our language as the reason why. So that's my.
So I totally agree with you.
Okay.
So we need to find a way to make it clear that meeting or not meeting doesn't mean that it gets held up. We're looking for progress reports. Hopefully better progress reports than we've received on the hours.
I mean, is there a possibility to have raise the age implemented and then receive these progress reports after raise the age is implemented?
The one thing that has to be in place to raise the age, I'm convinced of it, is a secure facility. Without secure facility, I don't think you can do it, because it's impacting the entire rest of the system. So it's supposed to be in place March 1st, right?
Could we have raise the age start upon the completion of the secure facility automatically?
No, I think it would go against our agreement. I would prefer to keep the April 1st date, but I would prefer language that makes it clear it starts April 1st. Whether they complete that or not. I'm trying to work an agreement with the administration. Yeah.
I really appreciate that you are trying to make something work and all of your work. I just remain unconvinced that they are showing up in good faith. And I mean, I really respect Commissioner Winter's honesty that he very well may be back here next year asking for another extension. To Senator Hashim's point the other day about sort of the trolley problem, which place are we doing more harm? Right now, we're doing harm on both tracks actively, and switching to one track just seems like I just feel like they've had years to do this stuff and happens, and I love the progress reports. I just can't in good conscience extend again.
So, but clearly, it would take an act of the legislature to change that date. So whether or not they say they can do it or can't do it, the next legislature would have to decide to delay the April 1st date. So making clear that you don't have to meet all these requirements in order to implement on April 1st. It shall be implemented April 1st. And I don't know how to, Eric is good at drafting stuff. He's drafting right now. But I think I'm in total agreement with you. I don't intend to give them another bite at the apple.
Yeah.
But I thought that having the progress reports for the Joint Justice Oversight Committee would keep the pressure on.
Well, I think the language here says that the reports are on its progress toward implementing the requirements of this act, that the Raise the Age initiative take effect. So it's kind of implying that they're making progress toward implementation. And if they don't, then we're not going to.
Well, I think it needs to be the opposite.
Yeah.
Yes.
So would language along the following lines possibly address the concern? What if you had, so you'd have a new subsection B that just said one sentence. Failure to meet one or more of the progress report elements required by subsection A shall not be a basis for extending the implementation of Raise the Age beyond April 1st, 2025.
Yeah.
Like you made it clear.
I mean, I get the basis for that language, but it still won't prohibit them from coming back and saying, we know that there's no requirement to meet all these progress reports or to, say everything's 100% for all these progress reports, but still, here's our status and, everything's terrible and we still have to delay again. They still, that out is still created, in my opinion.
Well, I don't think the next legislature has to give them that authority. Somehow, before April 1st, the legislature would have to pass a bill. Would be in, I suppose, budget adjustment or something like that. But the legislature would have to pass a bill that said that you could delay beyond April 1st. That you can't get around that. And if we're clear, what Eric just mentioned, if it's clear that it's not connected, the progress reports are helpful in understanding what progress you're making and dealing with the problem identified by the state employees, dealing with the problems identified by the department, et cetera. But if you're clear, then it takes a legislative action. That's my argument. So it's up to the next legislature if they wanted to give them another exemption. I don't, I would think I don't know who's gonna be in this room next year. Nobody does, but assume for a moment that it's everybody that's here right now. I can't imagine the majority of the committee giving them an extension. I don't know. I mean,
Yeah,
I mean, I didn't think we'd be seriously considering giving them another extension after we did this last year, honestly.
yeah, and the piece that's, that weighs on my mind is, you have the State Employees Association come in and they're talking about serious shortfalls in, workforce. And I understand that's a problem, but that'll be a problem next year. And it didn't prevent the first step in raise the age from performing well. And I know that they're saying now if you raise it another year, it's additional resources. I get that. But the other thing that I just want to say that I found troubling was that nobody from the administration was really willing to say, we're going to do this next year. I heard them all to be saying, we have doubts we're going to be doing this next year. And so I've just taken it as an article of faith that they don't really support the policy. And so I find it hard to take their testimony straight because it always seems to me to be inflected with this idea that they would rather not be implementing. And maybe that's too harsh a judgment, but it's been in the law for 3 years now, and they just seem committed to not doing it, rather than committed to doing it and just not there yet.
It's hard to disagree with that.
Yeah.
It's, I take comfort in the fact that we're in control.
If we're willing to say, you have to
We're
do it.
willing to say.
Right.
I can't predict what 16 senators might do.
Yeah.
But I can predict what the majority of this committee will do.
So were you saying, Senator Sears, that the secure facility is March of this year?
Yeah.
So next month?
Well, my understanding from the testimony of Commissioner Winters was that the bid up is ready. It's getting a provider who will run it. And I thought his testimony was they're in negotiations with a provider right now. I'm assuming, maybe it's not March 1st, but sometime in March. He said they had one provider who was willing to do it. And I think we've all agreed that for a number of reasons, even state employees have agreed that it should be a private provider, not the state. I have no idea who that private provider is.
Which was the
I
first
did
time
not hear the state employees say that. I heard the state employees acknowledge that there were issues and that they didn't have the capacity, but I did not hear them say it should be a private
I
provider.
did.
I did.
And I asked the union and they said absolutely not. They think it should be state
Well,
run.
I thought that's what Steve Howard said,
No,
or,
she said straight up, that they wanted a private provider because it was.
sorry, Steve, I didn't mean to, yeah, it was Terry,
Yeah.
just in case he's listening.
Oh, okay.
Yeah, no, I reached out to BSEA and because I thought that was strange and they were like, no, that's absolutely not our position.
Huh. Okay.
Well,
We should clarify that on the record.
Clarify, yeah.
well, but that's what, you're absolutely right, that's what
Yeah.
she said.
Yeah, but.
Like, I heard them saying they didn't think DCF should be running it, not necessarily that they didn't think the state should be running it.
Well, we could ask Steve to just
Yeah.
step
Yeah.
onto the record.
We'd like to reach out to Steve and see.
Huh?
We'd like to reach out to Steve and see if he.
Yeah, please. Okay. So we're at at 10:45, and we have a witness scheduled to talk about, would you want to talk about, Big 14?
Yes, I mean, it's really a policy decision for the committee. I think language-wise, you've reached the place where now it's just a matter of whether you want to make those modifications to the Big 12. And the language is in sections 1 and 2 of the amendment that you have in front of you now. Remember, what the amendment contemplates is 2 different changes essentially to the Big 12, and the Big 12 are offenses that begin in the criminal division when they're committed by a person 18 years of age or younger, as opposed to the family division. Under raise the age, as Senator Spears mentioned, that will be going up to age 19 whenever raise the age takes effect. But for now, it's 18 and unders, and 18 and unders start in the criminal division for the Big 12. The proposal is to essentially add 3 and take 1 away. So that would leave you with a total of 14. The 3 that you would add are on pages 2 and 3, bottom of page 2 over the top of page 3, using a firearm while committing a felony, trafficking a regulated drug, and aggravated stalking. Remember, the modification to those 3 also is that it's only 16 and over. It's not 14 and 15-year-olds.
Right, it would attempts are included, right?
That will, yes, that will have to be added. But that's
To be consistent with the other.
Exactly. Thank you, Senator Spears, for remembering that. So in addition to the attempts piece. So those would be the 3 additions, and the one taken away would be is over on page 4, very top of page 4, burglary into an occupied dwelling. Currently, one of the Big 12 proposal here is to strike that. So as I say, starting with 12, adding 3, taking away 1, leaves you 14. So language-wise, other than the attempts piece that you mentioned, Senator Sears, I think it's really a policy choice for the committee, what way you want to go.
Okay, so I'd like to go with that. Policy.
What page? I'm looking at draft 4.1. What page were you on?
It's not,
Oh, that.
it's a different draft.
I have another draft being printed right now, it's just taking time for them to go.
Thank you.
Get it, so I'll have it in the next 2 minutes.
I'm gonna speak strongly for this. First of all, trying to look at what's going on in Vermont, and these 3 new crimes added or attempts would be consistent with dealing with the problem. And also, I'm more determined than ever that firearms is a huge problem in Vermont right now. The use of firearms, not firearms themselves, the use of it in criminal activity. So my support for those additions to those 3 crimes, aggravated stalking, drug trafficking, and carrying firearms. It's a policy choice to take out the burglary into an occupied dwelling. But I think as I look back on this committee's work over the last, say, 20 years at least, this has always come up. What is an occupied dwelling? And the unintended consequences of what is an occupied dwelling become serious. And I think while I understand some state attorneys don't like losing that, they can still move to have it brought up into adults if they need to. But I think we're involving too many unintended consequences. When I think of an occupied dwelling, I think somebody's there. But that's not how the courts have defined it. And so I know we've had this is really over 20 years. I know we've had discussions. Michelle probably remembers when she first got here. This came up frequently. So I think it's time to change that. So I hope the committee will support the changes. I realize some members may or may not.
Yeah, I can support the changes to the Big 12. I still retain I retain concerns about other parts of the bill, but I'm fine with just changing the Big 12.
I'm sure it comes as no surprise, but I do not support the change to the Big 12. I remain really concerned about the unintended consequences of charging children in adult court without an attorney having to take action to make that happen. I still think it is a simplified process to start everything in family court, and in the rare instances where an attorney decides that a child should be charged as an adult, they should have to do something to make that happen. I appreciate the compromise of the addition starting at 16, but we are looking at data on Raise the Age of the incredible detriments of the criminal system on children. 14-year-olds are so young. My community.
I thought it was 16-year-olds.
For the new ones, but what I'm advocating for and have advocated for the whole time is that we eliminate the Big 12. That every child starts in.
Well, there's two of them.
That every child would start in family court, and if a determination was made that they should be tried as an adult, that the state's attorney should have to take decisive action to make that happen, rather than assuming that any child would be tried as an adult. We know how detrimental that system is to children, and in our community, we saw a 14-year-old charged, and we saw the incredible impacts that had. And my community has reached out to me in outrage that a 14-year-old was started in adult court. And so I think I remain unsupportive of adding anything to the Big 12, and in fact think we should be eliminating it in its entirety. And I recognize that the process for moving stuff up might need to be changed to make that a possibility. I think this is going to just do incredible wrong.
Well, I guess it gets back to the old saying, whatever has to be said has been said, but not everybody said it. We've been kicking this around for quite some time, and everyone feels very strongly about certain points and positions in here, but at this point in time, and I realize and listened to Senator Bohosky and Senator Bush's concerns, and right now I'm 99.9% in favor. So Senator Sears on this particular bill. Is there room for improvement? Yes. Okay, but I've listened to a lot of testimony, trying to leave the politics out of it, administration, so on and so forth. I listen to the workers. I'm in support of the bill as written.
And I can support this amendment and the bill with it. I think like S4 last year, it has some elements that I'm less comfortable with and some that I'm more comfortable with. But I do feel as though there's a palpable increase in violent crime using guns, and younger people using drugs in connection with the sale of drugs. And it seems to me that these additions are targeted at that in great part. So, and I appreciate pulling burglary from an occupied dwelling, because in all of our discussions, that seemed to me a different order of magnitude than the rest of these. So I can support the amendment and I can support the bill.
So why don't we draft it that way, but ask the Justice Oversight Committee to look at the process of moving juveniles to adult court, the proper term, and report back with any proposed legislation. So they don't have to report if they don't want to, but they would provide some proposed legislation to particularly, I share the concern when a state's attorney has an opportunity to wait a couple of days and decide how to charge a particular crime, that they feel compelled to charge an adult rather than hold off than move. And I don't know if it's the law or if it makes it more difficult or what it is, but we could add that to it. I think we can better understand that. I don't want to report though. I want it to be, proposed legislation if necessary. committee determines it's necessary to have proposed legislation. I think, a lot of things could have happened in that case, and it didn't. Hardly. Understand why. So, with that,
All right, I think it's those adding attempts, add that language to the progress reports about it not being grounds for not raising the age, and adding the language you just mentioned, Senator Sears, about the justice oversight proposed legislation on transfer from family division to criminal division. Sounds great. Good. I think those
Thank you,
are
Eric.
my sections. Yes, thank you. All right.
so now we're gonna go to Jean Murray, who's Director of Housing for Everyone Law Project, Vermont Legal Aid. And I wanna make clear that we're looking, what sections are you particularly concerned with in draft? Probably draft 5.1 is what we're working from, but you may not have that.
The language is the same with regard to the housing pieces, so that's no different.
So, for the record, I'm Jean Murray of Vermont Legal Aid. I am looking at S58. I'm looking at draft 3.2. So in draft 3.2, I'm looking at sections 4, 5, 6, 7, and 8. And I'm here to explain to the committee why I think that the bill shouldn't move forward with these sections in it.
That's section 14 onward for you guys' purposes.
Section 14 on.
So, a little bit about myself. I am an attorney at Vermont Legal Aid for 26 years and an attorney in Massachusetts for 7 years before that. My practice has always involved landlord-tenant law, always working on behalf of tenants who are trying to maintain their home. In the last 4 years, since the pandemic started, with federal funding, we were able at Vermont Legal Aid to intensify our efforts to try to prevent eviction. We do this because eviction doesn't solve problems. It never solves problems. It seldom solves problems for the landlord. If the landlord is using eviction to get paid and evicts a tenant that can't pay, the landlord seldom gets paid anyway. Eviction creates problems. Vermont has a homelessness problem right now. And so anybody who's evicted is going to end up homeless, or they're going to end up moving in with somebody who still has a roof over their head and put their tenancy at risk. So I am very acutely aware of problems in housing. And I really appreciate that the committee is trying to do something about the drug problem. I just strongly feel that focusing a possible solution in landlord-tenant law is not going to be effective to address the problem that you're trying to address. And by way of a little bit of an outline about what I want to say, is I want to say 3 things. Enforcement of illegal drug activity is not a civil matter. It's not a landlord's job. Landlords have jobs. They have certain things that they are supposed to do, but they are not equipped to prosecute illegal drug activity. The second thing I want to say is, the bill is suggesting due process changes based on allegations alone, not on proof, not even on sworn firsthand knowledge, but on allegations. The bill is proposing to change things.
I don't believe that's true.
Well,
It takes court action.
the way I read the bill is it would reduce timeframes based on the landlord's say-so.
There's timeframes in landlord-tenant law, there's timeframes in civil procedure. And based on the landlord's say-so, without any kind of adjudication of the court, those timeframes would be shortened. And the third thing that I wanted to say is that it's not going to be effective. We have had in the law, in the termination of tenancy law, for a while, the language that says the tenancy can be terminated based on criminal activity, illegal drug activity. So referring back to what I've been doing for the last 4 years, I've been looking at almost every single case that's been filed as an eviction case. Legal Aid and Legal Services Vermont have been looking at those. We send out outreach letters to all the tenants, and about half of them call us back. So we have certainly seen allegations like these. They're incredibly difficult to prove, especially from where the landlord stands, because the landlord doesn't have firsthand knowledge. The landlord can't be a witness and can't present admissible evidence. So in a way, holding out that this is going to help landlords is a little bit misleading to landlords. They can't get done what this asks them to do. So if you don't mind, I'd like to share my screen.
You've got about 5-10 minutes left at the most.
Okay. As I
You should be able to share your screen now.
Okay. As I was getting ready for today, I looked at some of the documents that have been submitted to you. Did I share my screen?
Not yet.
Sorry. Maybe it's not going to work. I was looking at a document that was submitted by Lieutenant Casey Daniel of the Vermont Department of Public Safety. And within his testimony, which is in your committee's records, he included a letter from a landlord, John Ruggiero. And one of the things that Mr. Ruggiero wrote is that he's a landlord, and when he's called the police for help, they have told him that enforcement of drug problems is a civil matter. It's not a civil matter. At some time in my practice, I also help victims of domestic violence, and for years we fought systems ignoring assault and battery, calling it a civil matter. It's not a civil matter where there are drugs being sold anywhere they're being sold.
We agree on that.
Okay. So there's another part of it. My section 4 must be your section 14, which amends Title 18 and adds something to it that wants to speed up the process. So the bill contemplates that.
That's the part where the person's not a legal tenant.
Yeah,
They don't have legal rights to that apartment. They're staying there. It's a trap house.
The question is.
That's what that's intended for, is to deal with the trap houses.
Whether or not someone, first of all, the words legal tenant is not a word I've seen in landlord tenant law before. But even if it was something that we all understood, the way that circumstance would work is either the arresting officer or the state's attorney would have to determine whether or not that person was a legal tenant. So that would happen with the way this works really fast. And if a person actually did have a possessory right to be in a rented apartment, but was prohibited by conditions of release to not return to that apartment, that would be something based, again, on allegations, not evidence, that the person couldn't be in their home anymore.
Let's see, they've got a gun on the coffee table, and they're holding the individual who rents the apartment hostage. They're selling drugs, they're doing other illegal activity, and we're trying to deal with that because the other 10 tenants in that apartment building are suffering because of the behavior of these people who are not tenants. And that's what this is designed to deal with, and if it doesn't deal with it, we need to make sure it does. But it's not designed to get into a debate about whether or not they're legal tenants. They're basically kidnapping people, holding them hostage for drugs or sex or whatever. This is going on in every community in Vermont, and it's time it stopped. That's what this is designed for. So I don't know if the language isn't right. I appreciate you letting us know. But that's what this is about. And I get complaints from other neighbors. And I know the police do. So it's more than allegation. You want to keep them there.
No, I don't want somebody to be deprived of their home without due process of law.
But it's not their home. They're not part of the lease. In this section, they're not legal tenants.
That would be a factual matter that would need to be determined whether or not there's their home or not.
Okay.
So here's my argument that landlords are not equipped to do what this proposed language asks them to do. Landlords do have responsibilities, and I made a little list of them. There's a common law theory called quiet enjoyment, which is when your landlord rents to you and you intend to use the place as a residence, and that's the agreement, and then the landlord changes that use. The landlord's breached the covenant of quiet enjoyment. There's peaceful enjoyment, which are words in the landlord-tenant statute, which is a tenant's obligation to maintain peaceful enjoyment of their neighbors. Landlords are also obligated to maintain a dwelling that's safe, clean, and fit for human habitation, and that's habitability. And landlords are required to look after the health and safety of the residents, which is now in that language. If they can evict for criminal activity, illegal drug activity, or violent acts, all of which affect the health and safety of residents. So landlords are supposed to provide a secure building. They're supposed to, whatever is needed based on the neighborhood, and like if you have a residential building next to a store where people are coming in and out, your security concerns might be different than if you live in a place in the middle of nowhere. So those kind of things, how the building stands, how the building is maintained. Landlords do have a duty to select tenants that are able to live up to the obligation of being tenants. But the other thing, which is determining whether criminal activity has occurred or illegal drug activity has occurred, this is not in a landlord's skill set, usually. They're not criminal investigators. They may have ideas about what is unlawful and what is lawful, but they don't know that for sure. They've not been educated in that.
Well, that's a good point. I don't disagree with that.
In order
So
for,
we need to make sure that there's actual police or state's attorney or somebody involved in charging the individuals, I guess. I thought that's what we were trying to do.
so.
I appreciate you bringing that forward.
So if a landlord, if the amount of time, I think you are familiar with eviction process, which is first there's a notice of termination of tenancy, which the tenant needs to receive. There's been a lot of definition about what notice and how it's actually delivered. So for example, in the Residential Rental Agreements Act, it's called by something actual notice, which is notice that has been mailed by first class mail or certified mail or hand delivered, and there's a presumption that it's received within 3 days, but that presumption is rebuttable. It can't be pasted on the door. That's not actual notice under the Residential Rental Agreements Act. In the Mobile Home Act, notice needs to be given by certified or registered mail. So there are lots of statutes in Vermont that define what is notice. The 14-day notice period is is pretty much the most minimal notice period, because in order for notice to be legally valid, it has to be delivered by actual notice and or for mobile home by registered or certified mail. When you reduce that notice period of time, the possibility that notice isn't getting to the tenant in time to respond to a termination of tenancy is heightened. And so it's not a good idea to shorten notice times like that. The other part of notice is the other part of the bill, I'm sorry, that goes on, I think, I can't tell you what sections you're looking at, but it adds a section to Title 12 that says, if on the allegations, if on what the landlord puts into complaint, in an action, as I believe what the statute says, in an action is brought by a plaintiff and it's composed by a plaintiff, in an action based on illegal drug
I think
action.
that's section 18 on page 17 of our.
Thank you. It says that a summons served in an action, instead of being responded to for 21 days, as the rules of civil procedure require, it needs to be responded to in 10 days. But again, this is based on what the landlord is putting in the complaint. There's no requirement in the statute for any of that to be verified based on personal knowledge, sworn under pain and penalties of perjury. So this would provide, and I want to say something about landlords in Vermont. There are 77,000 households that are renting households in Vermont, and most of those households and most of those landlords, 98%, there are no problems and people follow the law. I happen to be very well versed in the 2 to 3% now that relationship has failed. And of the landlords who are coming to court, the relationship has failed. There are a percentage that are trying to take advantage of loopholes. So I think all tenants in Vermont deserve due process when they are going to be put out of their home and made to be made homeless.
I appreciate your testimony and appreciate your bringing to our attention some of the problems with this section. The Economic Development, Housing and General Affairs Committee is looking at these sections tomorrow, I believe, to see what they think. But I certainly, I hope that we can revise that language to make clear that there needs to be some quick finding. But on the flash citing, that's, to me, that's section 14 on page 13 of the new draft 5.1. That's an extremely important section, given the testimony we heard from people at Decker Towers and others around the state who have, I feel bad for the tenants who are forced to live in these conditions. And that's who we're trying to look out for. So, and I also know people in my community who've been forced to live in some of these houses because there is lack of housing and the drug activity is so prevalent. Police are there all the time. I don't think there's any question that there's drug activity. Arrests have been made, etc. So if we require something more than the landlord just out alleging, I think there's been enough activity in these houses that we're focused on in this bill to make clear.
Well, as I say, I appreciate that Vermont has a drug problem, and it is reflected in some people's housing conditions. So I do appreciate wanting to do something about that. It's just the unintended consequences of it might be to make people who are innocent of wrongdoing homeless. And even if people have made mistakes and have used drugs and they lose their home because of it, it
Well,
doesn't solve the problem.
I gotta tell you, from my perspective, I feel more worried about the other 10 tenants.
I worry about it all. I worry about the homeless situation. I worry about the other tenants. I worry about the people who are gonna
I worry
lose.
about the people coming up from Massachusetts who move into apartments in Bennington, sell drugs, etc. Offer sex and other thing, and drugs to the tenant, and then hold the tenant hostage when they decide they've had enough and don't allow the tenant out. That's who I worry about. So this is happening in Vermont. They're called trap houses. And there are houses, there are mobile homes in all over my district. And I'm sure everybody else's where this behavior is going on. So that's what this was aimed at, frankly. Appreciative of your testimony, and we will look at these sections along with the economic development and housing in general.
Thank you. Thank you for your time.
So, Michelle, recognizing that there's work to be done on the housing piece.
John just had to run to the House General for
Okay.
10 minutes, will be back as soon as possible.
All right, well, we can talk about section 14 through 18 when he gets back. So,
Good morning.
good morning.
So I have, this draft does not have any changes to the kind of core sections that you've had in S58 that you've been working on since the beginning. You'll see the reader assist on page 9 where it says drug crime, starting with section 11, where you have your definitions for fentanyl, for xylazine, and for the new definition of knowingly for chapter 84.
What page you want to show, sorry?
11 starts on page, page 9, section 11.
Page 9, section 11.
So the definitions. And so you have your definitions there. Then section 12 on page 10 is your new xylazine offense, just making it an offense for dispensing and selling, not for possession, and has the veterinarian exemption. Bottom of page 11, section 13 is the selling or dispensing a regulated drug with death resulting. So no changes there. And then page 13, section 14 is the flash citation. Just to address a little bit of legal aid's testimony on that particular section, I can reach out again to the state's attorneys. They did see this language. I also had run this language by Judge Zone. I don't recall either one of them expressing any concern with this particular section. It is modeled after a provision that you have in current law right now with regard to domestic violence. I realize that it's a little trickier perhaps assessing whether or not someone is actually a legal tenant, but I think if you just look at the kind of plain language meaning of what a legal tenant is, and my assumption would be that if the state's attorney who is bringing the charge, has that information, it could be that the person who is the legal tenant says, yeah, this person is not on the lease, I don't want them here, then that can be contained in the information that is presented at the arraignment, as in terms of like that they would flash like them and have them arraigned the next day. If it's not clear, maybe it's that they aren't a legal tenant, but they're not able to determine that with any kind of rapidity, then they won't do this process.
Well, if they're not on the lease, I don't understand landlord-tenant law as well as I probably should. But I would think if they're not part of the leasing, they're not necessarily tenants, and if their behavior is such. I assume that the state's attorney is acting
The state's attorney is what, I'm sorry?
acting based upon,
I think if they're able to use this and they know that the person clearly is not a legal tenant, at that location, then they'll use it. There may be circumstances where it turns out that that person is not a legal tenant, but they couldn't ascertain that at the time. And I think they'll probably just go through the regular process. I don't know, but you'd want to directly inquire with the state's attorneys as to that, but.
so let's take a mobile home that's part of a mobile home park. And the behavior is such that other neighbors and stuff, and police have been called repeatedly, and law enforcement has been there. Wouldn't that be part of the report to the court? That record of, is it the land? I mean, I didn't think we were putting it on the landlord. I thought we were putting it on the law enforcement or state's attorney.
Yeah, this isn't put on the landlord. This is
Well, that's why I was
this is the
confused by
state
her
process.
Well, then I was confused by her testimony that it was on the landlord.
I think she was talking about the other sections with regard to if you're going to use this
But I'm talking about
media.
section 14
Right.
specifically.
No, I
Which
mean,
to me is the most important piece of the landlord.
right. I mean, it could be that law enforcement, is told by the neighbors, yeah, that guy, he's not, actually a tenant. He's just been crashing here for the last 2 months. I would imagine law enforcement could then contact the landlord and see if they could verify that, is Mr. Jones, a tenant here at this location? Is he part of the lease, or is he part of a sublease or whatever? There may be circumstances where they're not able to ascertain that like immediately. But again, I mean, in terms of how state's attorneys and law enforcement would use it, I would suggest you talk directly to them. But I don't see how section 14 puts some type of burden on the landlord. I understand what she's saying about the other one is that in order to utilize the process, there's not a check at the beginning, but that's how the law is currently set up, is that you can follow that process with regard to the shortened notice period if there's suspected illegal activity.
Okay. John, thanks for being back. We're talking about section 14 right now, and I think it's Michelle's judgment and yours that it's okay.
I had said that I thought with 14, Senator Sears was raising the issue about whether or not this section 14 with the flash citation puts too much of a burden on landlords, and my thoughts with them are that, it may be that if someone is cited or arrested at a certain location, Senator Sears said, mobile home park, and neighbors are like, yeah, this guy doesn't live here, but he's just been crashing here for the last 2 months. Law enforcement could, just do their due diligence in contacting the landlord and trying to ascertain whether that person is a legal tenant. And if they're able to ascertain through the landlord that the person is not a legal tenant, they can do the flash site, they'll be arraigned the next day. Maybe they won't be able to get a hold or ascertain information, and then they'll just fall back on the existing process.
Right.
But it's not incumbent upon the landlord to be doing anything affirmatively. And that the issue that was brought up before around your sections was that she was saying that because there's not like a court gatekeeping about whether or not you meet that status, that under the current law, in order to have the shortened notice period. So you're just following the model under current law.
That's right.
So.
Yeah, to the point about what the lawful tenant is, I mean, I agree with you that the burden wouldn't be on the landlord. Obviously, the landlord would be involved in the process of determining, but it doesn't mean that they have this independent.
Right. Do you want to come up? I mean, the thing that Senator Sears said, and I agree with him in the same place. He said, well, I just use the term legal tenant because I think that you could have kind of just a plain language interpretation of what legal tenant is, and there may be various ways that you may be determined to be a legal tenant, but other than like being on the lease or the sublease, I don't know other ways.
Exactly. Like you could have alternative language to say, for which
contract is in place between, but that would be exactly what someone would expect when they have to figure out what a lawful tenant is. So I sort of agree, spelling it out, and then in instances where people have unwritten contracts, you know, if you start to raise the concern whether or not that's meant to exclude that language if you start being precise in that particular
Right,
way.
because they might have an oral agreement or they don't have a written
Exactly.
comment, but it may otherwise be, you know, legal for them, and so I didn't want to prescribe it too much.
Yeah, but it's, I mean, the whole idea here is, what about the other 9 tenants? That's what this is about, really, this particular section. Or in the case of Deca Towers, the other 100 tenants.
And I think a scenario that you keep raising is the person who, you know, I guess for lack of a better word, is somewhat held hostage in a way by someone who they don't want to be there. You know, it's something like, you know, certainly with those types of cases, you know, the communication from the rightful tenant to law enforcement that this person is not on the lease, is not my roommate, my legal roommate.
No, I think,
So I don't have particular
is
concerns.
there anybody who's concerned with changes in section 14? You may not like the section, but is there anybody who thinks you're comfortable with the way it's drafted?
I have no
Senator Biles.
I have pretty significant, I mean, I don't like the whole section, but I have pretty significant concerns with
Well, you don't like the bill,
I don't, you're right.
so you can't talk.
Oh, that's not how you run this committee.
No.
No,
I'm kidding.
I know you are. My concern is in the mobile home section, the elimination of the ability, we spoke about it last time, that would allow mobile home landlords
I know.
to discriminate
What?
against certain
Right.
tenants. That is my, again, I don't like any of it, but that particular piece I have real concern with.
Okay.
Are we jumping to the, sorry, are we jumping to the
Page
remaining sections at this point? Are we done
I
with
think we're
section
done with
14?
section 14.
Okay.
And do you have other pieces on my sections that you wanted to?
No, I
there's
think we're
changes?
good.
Okay,
I
all right,
think
then I'll
we're-
let John take the
I'm
company
gonna
chair.
let John, have a few minutes, but I wanna recognize that hopefully the Economic Development Committee will take a look at this section, the sections 15 through 18.
They presumably will. The thing I would say is that in many ways, these concerns obviously are more of a judicial or kind of rights orientation than obviously they are dealing with landlord tenant. But I think that there's a reason these are addressed here in this committee, I would say. To return to something you guys were first discussing about whether due process is affected by allegations. This was something that Ms. Murray had said, and I think Michelle addressed correctly. It is true that what this does is shorten the periods that lead up to that, or that are part of that eviction process. So the notice periods, it does shorten them, and the basis of that shortening is an allegation. The landlord doesn't have to have proven that these things happen to shorten the notice periods. However, as Michelle stated, that aligns with what the statute already currently contemplates. We already have shorter notice periods, at least with respect to the termination notice, that are triggered on the basis of an allegation that criminal activity that's endangering the health or safety of others is happening, and that's the basis of shortening that period. So I would say that Ms. Murray is not misstating what's happening there, that the process afforded someone who's being alleged to have committed these behaviors, they are afforded less process because of that allegation, but it still remains the case that they're entitled to a jury trial and that those facts would need to be proven within that trial. So I think kind of all parties were right in what they were saying. I just wanted to try to clarify that if possible.
That's helpful.
Because it is correct that there are certain pieces of this where the shortening is based on the fact that a landlord is saying this is what's happening.
But throughout the language, like on page 14, lines 14, any of which threaten the health and safety of other residents. That's why that's there, isn't that correct?
That is why this is there, and that's to align with what the language in 4467B already says. That ties into
what's in existing law. We have an existing law, an accelerated termination notice period for conduct that falls into that bucket. Illegal drug activity or acts of violence, any of which threaten the health or safety of other residents. So that's a concept that's already built into law. This is piggybacking off of that to do an expedited
It's
eviction.
also on page 17, line 6, and page 18, line 4. So I think we're covering the bases with that term, right?
Yeah, this is just aligning with what we think will capture the kind of activity that y'all are trying to get at with a pre-existing concept that Vermont has already in the past recognized as being a basis for accelerating at least a part of the process. What this bill does is accelerates more parts of the process. The one piece where you would say there isn't really you might think of it as having a different concern is when we talk about on the final page, so page 18, the accelerated writ of possession, which is what actually puts someone, the landlord, back into possession of that property. The acceleration there is due process in a different way than the process that we're talking about here. At this point, a landlord would have gone through a full evictions process and would have proved, presumably, that they're entitled to return the property. So at this point, the acceleration that happens after that is, unlike the other acceleration pieces of this bill, following a judicial determination that something has happened. So there are slight differences in how you might think about due process concerns between those two pieces. But it is the case that in all instances, that tenant who's being evicted will be entitled to a trial. They will just be subject to this accelerated.
They could argue that it's not illegal.
Right. And
they can defend themselves and not legal aid probably provided with it.
And I didn't want to not respond to your concern. I realized we
Yeah.
were jumping in.
I was sort of looking at the whole housing section, not just that one section, so that's my bad.
But if we want to jump, I don't know where you guys want to jump to. I'm happy to talk about that.
No, I think this has been helpful. Is there anything else on this section that people want to discuss?
Sure. So I can jump in on, this is bottom of page 16, starting on line 12. So just to try to restate in hopefully clearer form, but I think that you're correct in your concern. We have in place in existing law, if you look at line 12, existing law says a leaseholder shall not be evicted when there is proof that the lease terms the leaseholder has been accused of violating are not enforced with respect to the other leaseholders or others on the park premises. The reason I take this to be in statute is that you would imagine if a landlord is bothered by particular kinds of conduct, that they would evict anyone who is engaging in that kind of behavior, right? That's what they would do. So if they're selectively enforcing against particular tenants, we presume that perhaps they aren't acting in good faith. If they really wanted someone out because they engaged in particular behavior, they would evict anyone who engages in that behavior. So the reason that we're able to make that inference from that behavior is that we presume it's sufficiently easy or simple or not sufficiently difficult for them to evict people. If it was too difficult for them to evict people, then it would be harder to make that inference that they are selectively enforcing on the basis of an impermissible purpose. So what the new language adds is it exempts from the application of this section. It shall not apply to eviction proceedings commenced against a leaseholder based on the leaseholder's criminal activity, illegal drug activity, or acts of violence, any of which threaten the health or safety of other residents. So this kind of activity, which you're creating the accelerated process for, would not be subject to this specific section, which is meant to elicit impermissible purposes for eviction. The reason that you might think that there's a different factual premise or why you might believe this is more appropriate in this instance than in other instances, and I'm not saying that you do, but the reason that you might think that is that if it is sufficiently hard to evict people for this kinds of activity, and I think that you had heard testimony that landlords are struggling to evict people on this basis, it becomes harder to make the inference that there's an impermissible purpose behind their selective enforcement. Does that make that's what I was trying to communicate last time, is that it's harder to read in the impermissible purpose, but it is entirely correct that people could hide an impermissible purpose behind evictions under this particular section.
So do we need lines 16 through 19?
Right, so you could you could pull this piece out. This doesn't disrupt the eviction process otherwise. This was just included for consideration if you guys were convinced that it's so hard to evict people on this basis that you were concerned they wouldn't be able to evict anyone, they can't evict everyone who's engaged in this kind of activity. But there's nothing about this that is required for any other piece of bill.
I think there is a legitimate concern about selective enforcement. So we like drug dealer A because he provides the landlord with drugs. But we don't like drug dealer B because drug dealer B is more violent or whatever. I think we could, I'm just one person, I think you can take that out and not impact the rest of the bill.
I certainly support taking it out.
The whole thing or just that?
I mean, I support starting over,
No,
but
just lines 16 through 19.
Yep, the whole revision of
Yeah.
that subsection B. Yep.
Yeah, it just,
On the end.
and so you cross out except as provided.
Exactly.
Because you no longer be providing an exception.
That's right.
You can't have a landlord selectively deciding who gets moved. If two tenants are dealing drugs.
And you can imagine pretty easily worst case scenarios where, as you say, if there's some relationship between landlord or park owner or the like, they may have reasons they want to keep particular tenants engaging in this behavior around.
All right, well, thank you, John. Sure. See you tomorrow. So we're gonna move on to a different bill. A different omnibus bill on bail. Actually, conditions of release.
196 or 195?
Well, it's actually 196, but will it be part of 195? I don't even know, have we taken this?
196? Yes.
Yes, did data you were not.
Yeah, we did a walkthrough and we've taken some testimony on it, but it was quite a while ago at this point.
Oh, we got another bill coming, okay.
So the bill on top is 196 as introduced, and then the bill underneath that is the new draft of 195, which been drafted yesterday.
And I just got back from,
196 in there?
yeah, and I just got it back from the editors and just have to make a few changes before. So this is still the unedited version of 195. So be kind, please.
So, draft 12.1, that's 196.
Actually got the wrong folder. There we go.
And you need a printed copy of 195?
195, yes. So you sleep already, so.
Oh, boy, I know. Now it's cooling down. I know. It wasn't very warm here. But there's enough to put it through.
That doesn't work anymore. There's a thing in your shoe.
Oh,
It's right next to you.
thanks for letting me know. Do you need it?
Yeah.
Thanks, Ben.
So, this is great bill. Gotten up to 26 pages. Can we focus on 196 and what section that is for right now?
Sure, well, and so.
Or
for the-
do you want to start, just go through the bill? What's the committee's pleasure?
I wonder if we have enough time.
196
20
is
minutes.
pretty short.
Yeah, 196 is a sentence or two.
Okay, let's just focus on 196.
Okay. For the record, my name is Ben Novogrodsky from the Office of Legislative Counsel. S 196, to remind the committee, is an act relating to the types of evidence permitted in weight of the evidence hearings. Right now, what this bill achieves, and if you were to turn to page 2 of the bill, it adds a new subsection B, that puts in the same evidentiary standard that's in the current bail statute, which is the evidence does not need to be conformed to admissibility standards. It can just be offered, and accepted. So what this would do would be to create the same standard in a weight of the evidence hearing. The current evidentiary standard, granted, if I recall correctly, there's been some testimony saying that some judges apply the standard inconsistently throughout the state. Some apply the standard under 7554, which is what the bill proposes to implement, or the higher standard, which has been used in 7553A and 7553, which is essentially a prima facie evidentiary standard. So that means that there must be, to get my quotation correct, that there must be substantial admissible evidence of that guilt exists, and the evidence can fairly and reasonably convince a fact finder beyond reasonable doubt that the defendant is guilty. So to break that down, doesn't mean that the evidence actually needs to be admissible, just that that admissible evidence exists. So what does that mean? So essentially there's been some cases, for instance, where there was an oral, a recording of a witness giving a statement to, giving a sworn statement to police officers that was admitted in one of these weight of the evidence hearings. That wouldn't necessarily be admissible because you need live testimony for it to be admissible evidence. So, but that was enough to meet the standard that it existed because they could get that witness to testify at trial. And that would be admissible. And the reason why
I can't find where you are.
Oh, well, this is just sort of giving the
Not in the bill.
general state of the law.
Okay.
And so the reason why the court has reasoned that what this does is that it balances the fact that you're not going to have to go through essentially a whole mini trial and with the same evidentiary standards that would exist at the actual trial in this weight of the evidence hearing. But it's a higher standard than just probable cause to balance out the individual's liberty interests because they're still innocent until proven guilty. So that's why this medium standard exists here, where it's not as demanding as it would be at trial, which is that reasonable person standard, but more demanding than just a probable cause standard. So what this bill would do, though, is eliminate this standard for at least weight of the evidence hearings related to violent felonies under 7553A. Yes.
And one thing I wanted to, we talked about this, it feels like years ago, but it was just in January, but can you confirm for me that that what we're trying to change is already applicable to 7553 hearings?
For life imprisonment?
Yeah.
That the standard that we're trying, that
the rules of evidence don't apply to 7553 hearings, but in some courts, they do apply to 7553A hearings, which is where we're getting this inconsistency.
No, I mean, based on the case law, that higher standard would apply to 7553 as well. But I think that there's been testimony that it's inconsistently applied.
Okay. My understanding was that it didn't apply to 7553, but I can go back and try to figure that out. So, thank you.
So I'm a little confused.
That's okay.
What are we trying to attempt here?
So what this bill is trying to achieve is to lower the evidentiary standard. So essentially you don't need admissible evidence to put forward evidence to show that evidence of the guilt is great based on clear and convincing evidence that the person poses a substantial threat of violence. And again, this is to back up for further context. This is for a hold without bail hearing when someone is charged with a violent felony. And to go through the process, the state must prove that there's an element, one of the elements of the felony involves violence, and that as a result, they may be held without bail when the evidence of guilt is great, and that's based upon clear and convincing evidence.
Which is a step below That's a step above probable cause.
Yeah, it was.
So why would we
Yes,
do
it's
that then? I don't understand. Where's this bill going?
I understand that the previous testimony from some of the state's attorneys said that what this does, specifically in crimes involving domestic violence, is that when there is admissible evidence that's required, it would require putting a victim on the stand to testify and potentially relive their experience. And so my recall of the testimony is that this would permit other forms of testimony to be admitted other than live testimony, to avoid that issue.
Would this have the impact of making it easier to hold people without bail, thus denying them of their right to liberty unduly?
Potentially. And the reason why is that it doesn't change the guilt is great standard. There still needs to be sufficient evidence, but it just wouldn't have to be evidence that has the possibility of being admissible at the time that it's presented. So they still have to present evidence.
Okay.
It just doesn't necessarily, it just wouldn't have to be live testimony.
Okay.
So there are other ways that they could present the evidence that may question the reliability of, or the veracity of that evidence, but it doesn't, it still requires evidence.
Okay.
And you'll see that in the bill, the last sentence of subsection B, it retains that guilt is great standard, that there still needs to be enough evidence. It just doesn't necessarily have to be admissible or shown to be admissible. It would just be anything that you could provide the court to support that the evidence of guilt is great.
And then my other question is sort of a technical question for those of us that didn't recently memorize all of Vermont statutes. What is 7553?
So, sorry, yeah, my apologies for that. 7553 is the hold without bail statute for offenses with the possibility of life imprisonment.
Okay, so these are different, and does this align the process with that process, or does it change the process? Like what's?
Well, I think that's where there's a sort of a difference of opinion,
Okay.
is that I do, as Senator Sheem alluded to, recall some testimony saying that the evidentiary standard is inconsistently applied.
Mm-hmm.
This would only change it for the violent felony hold without bail. It would not affect the life imprisonment one. And there is, for life imprisonment, there's still case law that's out there that says it still needs that higher evidentiary threshold.
Simply put, it's an attempt to get at geographical balance.
I think that's one of the goals, yes.
Okay, I'm just trying to wrap my head around this. So there is a higher, if we were to pass this, there would be a higher standard in 7553 than in 7553A, which arguably deals with lower level crimes.
Right. Well, I think currently you kind of package them together, and that inconsistency throughout the state applies to both, because there's nothing in their statutes right now that discusses the admissibility of evidence. That only exists in the bail statute 7554, which is the one with all the different conditions of release that can be imposed. There's case law, but I think there's a difference of opinion in how it's interpreted. The way that I read the cases is that those two hearings do have a higher threshold than the bail, and what this is doing is putting them on par with the bail statute.
I'd like to get clarification, because, I mean, I'm reading the opposite about 7553, and it's, and so I'd like to get some further clarification on this, because I've had a completely different understanding of it for the last several months, and perhaps, you know, just a quick testimony from Judge Zone might be good that way, because I know we're thinking about two different sides of the courtroom, but perhaps hearing from a judge as to what evidentiary standard does apply to 7553 hearings would be good. Like I said, my understanding was the opposite. And so part of my thinking was that if there was a lower standard for 7553 hearings, it wouldn't make sense to have a patchwork model for 7553A hearings, where in some courtrooms there is that higher standard and in other courtrooms there is not. And thus, in some courtrooms, you have a victim of aggravated domestic assault being required to testify within 2 weeks of the assault, whereas in other courtrooms, that's not required, depending on who the judge is. So,
Well, and maybe the differences lie in the fact that it's a different, I mean, there are different statutes, but we're just talking about the admissibility standards. And, you know, you can look at State v. Duff, State v. Bullock. But, you know, I mean, State v. Bullock, which is a 2017 case, is the person of the analysis talking about the evidentiary analysis, is that there is substantial admissible evidence that can be presented at trial. The state is not required under the standard to actually present such evidence during the course of a 7553 hearing, not a 7553A hearing.
right, so they're not required to present that at a 7553 hearing.
No, they are.
Which case are you reading?
State v. Bullock and also State v. Duff.
Where in Duff is that? I don't have Bullock in front of me, but.
So State v. Duff is 151 VT 433, year 1989. State v. Bullock is 2017 VT 7.
And what paragraph was that in Bullock?
And Bullock, paragraph 8. And it talks about, the next paragraph goes on to talk about the policy considerations, the boundaries, and why they chose that middle standard, essentially.
Stunned us into silence.
Not my intention.
So, anything else on this bill that we're taking up tomorrow? So everybody take it home, read it tonight.
I mean, if you'd like, I could.
196, you mean?
195.
195,
Yeah. Okay.
I mean, I could, do you want me
Yeah,
to?
I'd like to sit down and talk more about it, not right now, because the way I'm
195
reading
or
the paragraph,
196?
196, just the way I'm reading the paragraph in
Let
Bullock.
me ask you to work that out with Ben, because if we don't add 196 to 195, we can put it in the miscellaneous bill, or we can put it in, try to send it on its own. Because if you two are confused, then I'm confused, and Senator Bahowski is confused, and Senator Norris is confused.
Well, I'm not meaning to confuse anybody, but it's a very nuanced topic. So again, this goes to the fact that.
Let me try to state it, and then I'll see if I got it. Currently, you can have evidence presented in a weight of evidence hearing that may not be admissible in a court, but it would be video of somebody striking somebody in a domestic violence. This could be used as a weight of evidence hearing. However, in some jurisdictions, they're not allowing this type of evidence. This would make it a uniform system throughout the state to allow this type of evidence to be presented.
I think that's an accurate description.
Is that what you were hoping for in the intent of your bill?
Yeah.
Thank you, Senator.
Just one big happy family.
The question then between you and Senator Sheen is, does this do it? That's the question. That's what I heard.
Yeah, I mean, the first step is clarifying what does apply to 7553, and just because I'm having a different and I'm sure maybe there's something I'm missing here, but I'm having a different interpretation of what I'm seeing in these cases. And also based on past testimony as to what is applicable for 7553 hearings compared to 7553A hearings. And a big part of why I had the intent with this bill was the consideration of my previous understanding, which was that 7553 hearings have this lower threshold, but in some courtrooms for 7553A hearings, there's a higher threshold. And so it just seemed like an inconsistency that I was trying to fix, but.
Well, and I think where that inconsistency is how judges treat this standard itself. I think the standard is present in the cases, but it's what types of evidence meet that standard.
For 7553A.
Right, well, and I would argue for 7553 as well.
So for me, getting an answer to this question is pretty important because I feel uncomfortable lowering the standard in one area than where it is in another area when we're talking about people's liberty interests. So getting the answer to like, is that effectively what this is doing is going to be really important.
So we can schedule Judge Zone tomorrow.
Judge Zonet's already coming in.
He's already coming in,
Perfect.
so just alert him that this question is coming up. Senator Norris has adjourned the committee.
Okay.
I've noticed that you get up and
I do the
taking
same thing
away
in the
my
other committee
power.
too.